Duty of good faith. Is it now time for English law to embrace a duty of good faith in the performance of all contracts? Good faith is the general idea that both parties subject to a contract will act in accordance with fair dealing, honesty, and in good faith as to not withhold information from the other party for their own benefit. As J. Leggett best put it in his lecture to the Commercial Bar Association 2016, good faith is best understood to be constructed of the two elements or aspects of 1. Adherence to reasonable commercial standards of fair dealing, and 2. Faithfulness to the agreed common purpose of the contract and to the reasonable expectations of the parties arising from it. A concept that has been widely associated with J. Morgan from the ruling of the Berkeley Community Village v. Pullen case, which notoriously translated the ambiguous definition of good faith to include the observation of commercial standards of fair dealing, as well as faithfulness and consistency to legitimate expectations of the parties. The concept of good faith has not yet been recognised as a duty in English law that all entering a contract must adhere to. This has long remained a contentious issue due to the success of the duty of good faith in the performance of contracts in other jurisdictions, leading J. Leggett to famously note how English law was swimming against the tide in not recognising the notion of good faith. For example, in Germany, the contracting parties must observe good faith in both the negotiation and performance stage of the contract as stated in the German Civil Code. The code has been used to establish ancillary duties to the contracting parties, refraining either party from engaging in actions that may compromise the contractual purpose, and sometimes can even protect a party from a conflicting third party. This has been a key ideal within German civil law, and has seen great success despite there being no established strict definition of good faith within the Civil Code, but has the benefit of providing flexibility that can be interpreted by judges as shown by case law. The US demonstrates a common law approach to principles of good faith, so long as the state has adopted the Uniform Commercial Code, which imposes an obligation of good faith in its performance or enforcement. Unlike other jurisdictions, such as Germany, good faith is defined and is outlined as honesty, in fact, in the conduct of transaction concerned. The US also follows the absolute rule that the presence of a contract automatically imposes a duty of good faith onto the contracting parties, which has been extremely successful in eliminating the ambiguity often associated with the debate surrounding good faith, as shown by cases such as Court v. Levy, which ruled that if a tenant's actions were confirmed, they would violate the duty of good faith, an applicable ruling to all US cases. Although English law has not recognised the duty to perform all contracts in good faith, the ideal remains a contentious issue due to those believing honesty and fair dealing does already have a place in English law proceedings. The UK's membership to the European Union before the referendum in 2016 meant the adhering to European law, of which the principle of good faith was classed as a general duty in the Principles of European Contract Law in Article 6102, was mandatory. Not only this, but Section 62 of the 2015 Consumer Rights Act also introduced the idea of good faith into English law under the guise of fairness and determination of what an unfair term may be in a contract. As highlighted by Lord Bingham in the Interphoto v. Stiletto case, it may be best to describe the situation within English law as having no overriding principle or good faith, and instead having developed piecemeal solutions in response to fairness, as shown by cases where an express term of good faith in a contract has been considered by the courts, which will be discussed later in greater detail. The concept of good faith was brought to the attention of English courts again with the case of Yamseng, which dealt with an international trade corporation granting Yamseng the exclusive rights to distribute fragrances in specific parts of the world. However, the contract later was terminated due to the belief that ITC had breached the implied term of good faith by giving false information to Yamseng regarding product availability and dates of supply. This case is significant in the argument that it is time for English law to adopt a duty of good faith, as it acknowledged that ITC had in fact made a breach of contract, as it had a duty to be honest, a crucial element of good faith. Justice Leggett placed an emphasis on honesty in this case by coming to this ruling on the grounds that honesty is applicable to all contracts and that a breach of it is determined if it could be regarded as commercially unacceptable by reasonable and honest people. This approach by Justice Leggett to the interpretation of good faith could be of extreme value when deciding if English law should adopt a duty of good faith, as it provides a more applicable criteria to an ambiguous concept. However, J. Leggett's suggestions had little impact on the progression of good faith being integrated into English law, as shown by the Mid-Essex Hospital v. Compass case, where it ruled that there was no express good faith obligation with an implied term. Although J. Beatson did use J. Leggett's ruling in Yamseng to come to a decision for this case, it was decided that care must be taken to ensure that with an implied term there is not an open-ended obligation to act with good faith, which may be used against the other contracting party. Despite J. Leggett's valuable insight into how the duty of good faith may have a role in English law, good faith still proposes a lot of problems. A prominent issue that was raised in the case of Hampstead v. Boots was the possible imbalance of power the duty of good faith can impose. In this case, J. Norris ruled that implied good faith is an obligation placed onto a contracting party to force its own commercial interests onto them. This could be a significant issue if English law decided to integrate the notion of good faith, as it may deter people from entering contracts due to fear of being subordinate to the other contracting party. Another relevant problem when discussing good faith is the issue of ambiguity. Even in jurisdictions with the notion of good faith being integrated into their laws, such as France, struggle with the issue of ambiguity. Lord Ackner in Walford v. Mars exposes the issue of good faith in English law as being completely unworkable in practice, as it is inherently inconsistent with the position of a negotiating party, as problems such as how is a vendor to know he is entitled to withdraw from negotiations, and how is the court to police such an agreement due to the ambiguous definition and role of good faith are called into question. Lord Ackner also posed another issue in the matter of good faith being integrated into English law, as he considered the nature of the commercial world and how a compulsory duty of good faith may contradict the nature of a contract. In Walford v. Mars, Lord Ackner suggested that the nature of contracts is to look out for the interests of each individual contracting party, and therefore tying another party into an agreement where they must tailor their own actions simply to act honestly seems self-defeating. Good faith has been debated in UK courts depending on whether it is an express or implied term. Express term meaning that it has been written into the contract, and implied meaning an unspoken expectation by one or both of the parties. Contracts can have the ability to include a duty of good faith, of which the contracting bodies must abide by in UK courts if included as an express term. Courts in these cases will give effect to the parties' intentions, however, are not bound to impose the clause upon the parties. This is explored further in the case of Mid-Essex Hospital v. Compass, where the courts refused to accept a clause of general good faith. Instead, the clause was limited to the circumstances where it was relevant, as stated within the contract, to ensure that both parties weren't bound by an open-ended obligation of good faith. Although Yamseng did not establish a general implied duty of good faith within all contracts, there have been some examples where an implied duty can exist. Lord Hoffman, in Attorney General of Belize v. Belize Telecom, granted the implied duty of good faith relevance so long as the question for the court is whether such a provision would spell out in express words what the instrument, read against the relevant background, would reasonably be understood to mean. This attitude aids the understanding for the ruling of Yamseng and can grant an implied duty some value within the law. It is possible that good faith in all contracts may not even be necessary, as it could remain implied as a general principle within a contract. This is especially relevant when considering relational contracts, which are based upon a relationship of trust between the two parties. In Bates v. Post Office, the courts ruled that relational contracts have an automatic duty of good faith, transparency, and fair dealing, suggesting that perhaps relational contracts may be exempt from being explicitly mentioned within a contract. In conclusion, I don't agree that it is time to embrace a duty of good faith into the forms of all contracts, as it may conflict with the best interests of the involved parties, and remains an ambiguous concept which must be defined in greater detail if it is to begin to make its way firmly into English law, even with J. Leggett's suggestions in Yam Seng. The approach of putting a limitation on the boundaries of good faith, as demonstrated in Mid-Essex v. Compass, could be an extremely beneficial way of incorporating the duty of good faith into English law, as it helps to eliminate the issue of ambiguity, as well as imbalances of power, as both contracting parties have agreed upon the terms of how the parties may engage in bad faith. Therefore, yes, the UK may be swimming against the tide, considering the position of good faith in other jurisdictions and the success it has had. However, the wishes of the contracting parties at the time of making the contract must be held as the most significant issue when considering good faith, and therefore constraining the boundaries of good faith to a limited express term and a very clearly indicated implied term should be sufficient in granting the benefits other jurisdictions enjoy from integrated good faith without compromising the nature of a contract.